Hello, my name is Henry Hawkesworth and I'm a junior here at Pump Court Chambers. And this is, I think, part of a series in what I hope will be many introductory talks about various subjects in the sphere of civil law. What this talk is not aimed at is credit hire ninjas, black belts, other such individuals who are already very familiar with the law. In that case, I think I'll be preaching to the choir. What this talk is aimed at, or who this talk is aimed at rather, are people who are perhaps not so much familiar with the law, who might be coming to it for the first time, and who are looking for a kind of a broad overview of how these claims work. And that's what I shall be endeavouring to provide in a sort of stock cube format. So let's get going, shall we? So the underlying facts of a credit hire case are all pretty much the same. So the general principle is that the loss of the claimant's vehicle, if they've been involved in an accident and they're not the party at fault, that can be mitigated by the hiring of a replacement vehicle. And the cost of that replacement vehicle will be the measure of damages that they can recover from the at-fault driver or the defendant for the loss they've sustained. Generally what happens is that the claimant driver is involved in an accident with the defendant driver. And usually what happens is that they'll phone up their insurer and they will explain what has happened. And instead of making a claim on their own policy, what will happen is the insurer will say, we can put you through to a claims management or an accident management company, and they can deal with it for you. And by that happening, you won't risk an increase in your premiums. Either that, or the claimant can go directly to the accident management firm in question. And now, as I've said here, the insurer might deal with the repairs aspect or the total loss aspect. But in terms of the replacement vehicle, that's usually dealt with, of course, by the claims management company. And the claims management company will say they offer a one-stop shop to the claimant. They'll say, we can deal with your repairs if you want us to deal with that. We can deal with providing you with a replacement car. And if you've been injured, we can provide you with perhaps a sort of a medical service of physiotherapy. And the use of the vehicle provided to them while their own vehicle is being repaired or is being assessed by an engineer because it's a total loss. That vehicle will be provided to them to rent or to drive, pardon me, not rent, to drive, but it will be extended to them on credit. So they won't have to pay for it up front. And the general idea is that there will be a term in the contract obliging them to make a claim against the at-fault driver if the sums aren't recovered from the at-fault driver. And so that will be the hire company's assurance in that regard. And usually the solicitors who conduct that sort of litigation are affiliated with the claims management company. But as I say here, the cost of the credit hire vehicle, as invoiced by the credit hire firm, is often significantly higher than the cost of an equivalent vehicle would be on the general market from a provider like Hertz, for example. And the reason for this is, of course, the hire vehicle has additional benefits with it, the most obvious being that it's being hired on credit. And we come to that next. So one of the first important cases in which this was being discussed was Diamond and Lovell, which essentially explored, or part of the judgment, explored the reason why credit hire companies charge such higher rates for their vehicles than your average hire company on the high street. And he identified Lord Hoffman in this case, identified several elements in which additional benefits were being provided. So here, of course, he's saying that obviously the main one is that the vehicle is being provided on credit. The claimant isn't having to pay for it up front. The hire company might be pursuing a claim against the at-fault driver, and the claimant is relieved of the worry about that. And of course, it may well be that the claimant, having made the claim against the at-fault driver, of course, won't have to pay any of the shortfall if not all of it is recovered. That is the final of these four sort of limbs here, which Lord Hoffman identified. And of course, what's the important bone of contention here is, in English law, a claimant is not able to recover the expenditure which essentially secures those extra benefits. The claimant can only go on to recover the spot rate, or in other words, the amount that it would have costed them to go to a regular provider. Now, the exception to that rule, of course, is where the claimant is deemed to be impecunious, but we're getting ahead of ourselves there. We'll come to that later. So this is what Lord Hoffman essentially said on the point. Doesn't regard any of those extra services the credit hire company is providing as being compensatable loss. And so what essentially the recoverable amount is, as Lord Hoffman says at the bottom here, in the case of hiring from an accident hire company, the equivalent spot rate will ordinarily be the net loss after allowance has been made for the additional benefits which the accident hire company has provided. So those additional benefits need to be stripped out of the amounts that the claimant is claiming and removed. And then whatever remains, that is the essential quantum of what can be recovered. And this is a principle which has been stated over and over again in the case law. And if you don't believe me, don't take my word for it. Essentially, these are the cases, or some of the cases, in which the principle has been stated and restated. So, I don't need to read all these out to you. These are the essentially cases where the central facts have remained the same, and the principle has been restated. And the general idea is that if one is to strip out the benefits from a credit rate, then what you are left with is the rate that is provided by a high street provider. And this is the bone of contention that most of the litigation in the county court springs from. It's this debate about what the appropriate quantum of loss is once you strip out those benefits, what the appropriate basic hire rate actually is. But I'm going to row back from that now and talk in slightly more practical, less abstract terms. So let's take a hypothetical hire claim. So let's imagine that our claimant is Mr. Dickens. He's parked his car, a Fiat Punto or something like that, on the side of the street while he's buying his fish and chips. And while he's in the shop getting his fish and chips, Mrs. Bronte has come into his car and hit the rear bumper. And Mr. Dickens will then call up the car hire company and tell him that his Fiat has suffered a broken bumper. And he'll drive his car home, and the following day, what will usually happen is the car hire company will send an engineer to come and inspect his vehicle. And the engineer might decide that the vehicle isn't roadworthy, in which case it can't be driven for the period. Well, it can't be driven on the road legally. Or it may well be that it is repairable, but those repairs might take a period of time, and then the garage might not be able to accommodate the vehicle for a couple of weeks. So this is not a personal injury case, because Mr. Dickens hasn't been injured whilst he was buying fish and chips. But obviously, it's an important part of litigation that the claim has got to be pleaded. And so the first thing I want to discuss with you is essentially how to plead the case. So the first thing to look at is Practice Direction 16, paragraph 6.3 and 6.4. So Mr. Dickens has gone to the hire company. He's been provided with a hire vehicle by the credit hire company on credit terms. So he has understood that there are charges which he's liable for, but they've been extended to him on credit. So what the practice direction here quite clearly sets out is that what you need to lay out in your particulars of claim, if you're a claimant and you're claiming that cost. So you need to lay out why Mr. Dickens needs the vehicle. You need to lay out the dates of the period he was provided with the credit vehicle for. You need to provide the rate at which the credit vehicle was extended to him, the daily rate. You need to explain why that period was reasonable. Usually it'll be because that was the period it took to get the car repaired or replaced. And then you have to plead this issue of impecuniosity, which I'm going to come on to later, essentially whether Mr. Dickens could have afforded, if he had the funds or not, to have hired a car sort of from a provider on the high street or the spot rate. Now, of course, this is, I'll come on back onto the obligation to plead impecuniosity, but these are all pretty obviously basic requirements. Moving on, of course, most of you will be familiar, of course, with Civil Procedure Rule 16. Particularly as a claim, if you're making the claim, they have to include a concise statement of the facts upon which you rely. But I think a further aspect, if you are dealing with credit hire, which it's important to be familiar with, is Practice Direction 16, paragraph 7.3. If you're from the credit hire organisation, there will be a written agreement. Well, I hope there will be a written agreement between the claimant and the credit hire company, the accident management company, which is providing them with the vehicle. And if that is the case, and I hope it is, because otherwise you might face some difficulties further down the line, you should attach that written contract to the particulars of the claim. There's a provision in the practice direction that the original documents should be brought to the hearing, although I think very often that doesn't happen. I don't think it's a particularly, in most cases, it's a great tragedy that it doesn't happen. It's simply belt and braces approach. So there's been some recent case law about the importance of a full pleading, especially in regards to the impecuniosity issue. I think in this particular case, Dirier and Bojaj, it wasn't quite on point because it was talking about compliance with an unless order that a judge had imposed. But the general principle, as stated here by Lord Justice Coulson, it is a familiar one. The information relevant should be provided. And if it isn't, certainly in large claims of credit hire, you can expect judges, certainly in the county court, to be quite careful about scrutinising points which haven't been properly pleaded. So moving on from the simple process of pleading the credit hire issue, it's important then to consider essentially from a tactical perspective what track you might be wanting to go on. Of course, if there's a personal injury element above £1,000, you'll be looking at the fast track anyway, and you ought to be following the pre-action protocol in respect of claims of personal injury in those cases, and that's its own separate thing. I'm not addressing that in this talk. But if what you have is a large claim for hire, no claim for personal injury, of course, if it's below £10,000, it'll probably be allocated to the small claims track, where the costs you can recover if you're a claimant are significantly limited. Now, if you're a claimant and you're in a credit hire context, there's a very good chance that the defendant will have already admitted liability, in which case it may well be advantageous for a claimant to try, if the claim is even slightly above £10,000, to ensure it goes on the fast track, because the claimant is then entitled to a package of fixed costs. Well, it will indeed fixed costs for the trial, but of course they're then entitled to their reasonable costs of pursuing it up to the trial. So that may well be attractive for a claimant. So just to correct myself, the fixed costs will only apply in a personal injury case. If it's a simple matter of just credit hire, then there are some fixed cost provisions about the cost of a trial advocate, but the costs you can recover essentially are the regular simple costs of the action. So it may well be that a defendant won't want that to happen, because the defendant won't want to pay for a parcel of costs. And defendants would do well to remember Civil Procedure Rule 26.8 when looking at a credit hire claim. They may want to admit part of it, and by doing so ensure that it ends up on the small claims track, and thereby save their client perhaps a considerable chunk of costs. But however, if the defendant wants to do that and admit part of the claim, then what they can't do, and this is a case of Akhtar and Boland, What they then can't do is go on and make assertions within the claim that are inconsistent with them having already admitted a certain amount of money. So, for example, if the claim for credit hire is shall we say, £20,000, and the defendant decides that in order to bring it within the small claims track, they'll make an admission of just over half that amount. So the amount falls below £10,000. It then won't be able, the defendant then won't be able to turn up at the trial of the small claims track matter and then argue about whether the claimant needed a hire vehicle. The concession they've made by implication indicates that they'd accepted that there was a need and therefore some of the costs are recoverable. But I thought I'd lay that out because it's an important point. And sometimes you do see credit hire claims which have only just made it into the fast track, and you think, well, the defendant really could have saved themselves a lot of cost here by simply making a reasonable admission of part of the claim. So something to consider there. So before we then move on to some of the more regularly discussed issues in the county court, I thought in this talk, although brief though I'm trying to be, to discuss a hot topic at the moment. So we're now getting to the point where we are considering what issues to argue in our pleading, if perhaps we are a defendant. And one of the hot topics at the moment is illegality. And it doesn't arise too often, but it's becoming increasingly important. And as I say here, it is a hot topic. So let us imagine, if we go back to our case of Mr. Dickens, whose car Fiat Punto has been damaged. If after obtaining his hire vehicle from the hire company, it then transpires by whatever means that he was disqualified from driving because he's totted up 56 points on his license, and therefore he was driving whilst disqualified. The question here is it possible for him to essentially have a claim for credit hire where it's obvious he should not have been driving in the first place? So the general principle here is if ex turpi causa non oritur actio. But if you're not hot on your Latin, don't worry. I'm not here to judge. The rule is stated by Lord Mansfield in a very early case called Holman and Johnson. Essentially, it's that no court will lend its aid to a man who founds his cause of action upon an immoral or an illegal act. And the leading case in this area, and it's quite an interesting area, I think, is a case called Hewison and Meridian Shipping, PTE. I'm not going to go into the facts of that case for the purposes of today, but it's certainly worth reading. The principle, I think, that it elucidates is that where the illegality is central to a claim, then the claim ought to fail. But on the other hand, if the illegality is collateral or insignificant, then the claimant can still make a recovery. Now, the only case which has been widely reported where I think this has been properly applied in the credit hire context is a case called Agiampong and Allied Manufacturing London Limited. Now, this was a case where, as I understand it, that the claimant had driven without insurance for around 16 months before going into into credit hire. Now, we know that it's open to individuals to insure their vehicle at any time, and they can, of course, even insure it retrospectively in some cases. And so in this instance, the court found that in order to say that the illegality was central to the claim and to establish this argument, what the defendant had to show was that on balance of probabilities that the claimant would not have insured their vehicle throughout the currency of the hire period had they been allowed to continue to drive their vehicle. And the judge found that because this particular claimant had already been driving for 16 months prior to the accident without insurance, it was likely to be the case that he would have continued to drive without insurance. And on that basis, the claim was defeated. Now, it's clear that it's not entirely a black and white area, that there's still a great deal to be argued about in this particular area. And it seems that where a claimant genuinely has mistakenly forgotten to insure their vehicle, maybe for a matter of a few weeks, or where there's a similar situation with MOT, it may well be that based upon the principles in the Aggie-Ampong case, that would be recoverable. But I think it's worth pointing out a case which is on the Pump Court website called Shadbolt and Stefanatica, where I think the point was made that essentially providing a claimant with a vehicle upon which they have a valid MOT, where prior to the accident the claimant was driving a vehicle that didn't have a valid MOT, that would amount to a betterment. Essentially, the claimant was being put into a better position. So before the accident, the claimant was not legally permitted to drive, and so by being put in a position where they could drive, that essentially was improving their situation. I think the claim was dismissed. Ultimately, it's a public policy kind of an argument in this area, and the onus, of course, is on the party alleging it. That's usually the defendant. But there's a great deal to argue about here, and it's not entirely settled law, and it's not been decided on by the Court of Appeal recently. And so it's an interesting area which I think deserves some attention. It doesn't often arise, but when it does, it can be quite determinative, I think. So moving on from illegality onto slightly more common ground, we move on to the issue of enforceability. Now, I'm just going to tell you now that this talk doesn't address Consumer Credit Act arguments, because they so rarely arise. I'm just going to talk about the two other main arguments which relate to enforceability, and those are misrepresentation and unsigned or late hire agreements. Now, I think it does no favors to enforceability to think of it as a point unique to credit hire. Enforceability arguments arise in contract law all over the place. They are a contract law argument. They're not specifically a credit hire argument. So the first area which I'm going to address is where there's no signature on the hire agreement. Now, as I think is obvious, the credit hire companies will very rarely allow that to happen. They will usually secure a signature on an agreement, if not prior to the hire period, then at some point during it, or indeed afterwards. And however, if it gets all the way to a trial and they still haven't managed to obtain a signature from the claimant, obviously questions do arise in that case as to whether there was a binding agreement, an intention to create legal relations, or whether there is an enforceable liability. These are agreements where you would expect there to be a signature. As far as I know, there's no reported case where no signature at all has appeared in a contract. But as I say, it's likely in those cases that a district judge or a circuit judge dealing with a fast track or any kind of track really claim would be quite ill disposed towards the claim. And of course, I don't think that'll be surprising to many of you really. But the more common circumstance is where there has been a late signature, and so where the hire period has started and the signature only appears on the document after the hire period is ended, or at some point during the hire period. And this has been addressed in a number of cases. I think the most forceful statement of principle is in the appeal case of Armstrong and Hussein. So it's a county court appeal, so it's not a binding authority, but it's quite a forceful statement of the principle that, generally speaking, it's not uncommon for contracts to be to begin and then be formalised at a later date. And of course, those familiar with, remember going back to their contract law exam will recall it's perfectly possible for a contract to have started without a signature and be formalised later, or indeed there be no signature at all based upon the conduct of the parties. But in this case, I think what His Honour Judge Freeman indicated was that it would be a commercial nonsense for there to be an enforceability argument where the claimant had indeed signed the agreement, albeit somewhat late. So I think in terms of the late signature argument, if the signature does appear on the document upon the credit hire agreement during the currency of the hire period or shortly afterwards when the claimant has signed it, generally speaking, there won't be much of an argument about, I think, late signatures. The, I think, exception here in the reported case law is another county court level case called Company Call Centre and Sheehan. That is a case of quite extreme facts. I think in this case the claimant, as you'll see, is a company, and there was a considerable, I think, delay between the period of hire and the signing of the agreement. I think the period of hire was the 19th of March to the 3rd of April 2007, and then the document wasn't even signed until the 12th of August 2007. So there was an extraordinary delay in signing the contract in that case. And in that particular instance, there was no evidence that the terms and conditions were available to the claimant whilst the hire was ongoing. And in the Company Call Centre, there was also no evidence the company had entered into an oral contract at the time of the hire with the hire company. And based on those two pieces of evidence, the judge took the view that past consideration is not good consideration and dismissed the claim for hire charges. So that's quite an extreme case. You often see it cited by defendants in their defences in cases of late signatures. But I think that is a case with fairly extraordinary facts. But it is something to be aware of. The other enforceability issue about whether there's an enforceable liability to pay these charges is where there's been a misrepresentation. Now, this was thrown into strong relief in the case of Kadir and Thompson. What essentially needs to happen for a defendant to establish that there was no enforceable liability on the claimant to pay the charges because of a misrepresentation is that the defendant has got to establish, usually in cross-examination, because there's no other opportunity usually to do it, that there was a false representation of fact or law made to the claimant by the credit hire company. So that would be that what they were getting was a free car, that there was no liability to pay under any circumstances, or that this was a courtesy car. So that would be the kind of misrepresentation that you'd be looking for in cross-examination. You then need to demonstrate in your cross-examination as a defendant that that misrepresentation is what induced the claimant to enter into the contract. So that the idea of there being a free car or courtesy car is what persuaded the claimant to enter into the contract. And then within the cross-examination itself, the defendant must then get the claimant witness to void the contract. So to indicate that they would wish essentially to void it. So those are the three steps that you need to establish. And of course, the burden falls upon the defendant in each of those cases. It goes without saying that that's quite a tall order in most cases. In my experience in the county court, when you ask people what the oral discussions were at the time with the credit hire company, they tend to come back and say, well, I can't really remember. And that will often be what they say in their witness statement as well. And some credit hire companies even go to extraordinary lengths to essentially ensure that at as few points as possible, they have conversations with their representatives. They tend to do everything through email. In a 90-minute small claim, it is hard to establish a misrepresentation. Now, the enforceability point has been examined a little bit more in the Court of Appeal in a case called Irving and Morgan Sindel. And what that case established was that if the claimant assurances were made to them by the credit hire company, that what the liability was a contingent liability. And to explain that, the liability which arose on the condition that they recovered damages in their claim against the defendant. and so there would only be a liability to pay the credit hire company if those damages were recovered. That wouldn't compromise the claim for credit hire. So in that case, Mrs. Irving was explained that she was told it was a kind of a no-win, no-fee agreement, and that she understood that the damages that she was essentially liable for, that the charges for credit were being claimed against the other side as part of her claim, and that essentially was a contingent liability. Well, Irving Morgensentel says that if that's what the claimant understands or was represented, that was what was represented to the claimant, then that won't compromise the claim for hire charges. So that's been clarified there. So then once it's been established that this is an enforceable contract and that the claimant does have a liability to pay the credit hire company that they've taken on, the question then moves on to one of need. There's no magic about this. The general principle about whether the claimant has established or proved that they needed to hire a vehicle in the first place was laid down in this case of Giles and Thompson. And the general prevailing view has taken this forward. It's not self-proving, so that the claimant does need to come over that evidential hurdle, even though it's not a particularly high hurdle. And the key passage, which is often cited by claimants, is that it's not hard to infer that a motorist who incurs the considerable expense of running a private car does so because he has a need for it, and consequently has a need to replace it. So generally speaking, there'll be a strong inference there if the claimant has a vehicle, that they have it because they need it. That is not to say that need should go unchallenged. It's not uncommon, in my experience, for evidence to emerge at the trial from the claimant that they have another vehicle which is usable, or perhaps that they were away for part of the hire period, which meant that they didn't need the vehicle for that portion of it. It certainly it's not something which is not worth exploring. Then there might be a question about whether need can be established if the claimant is a company with a fleet of vehicles, or just a general corporate claimant. And this was, I think, addressed in some detail in the case of Singh and Ikubi, which is a 2013 Court of Appeal case. Of course, the key here is that for such a business claim to succeed, the judge was entitled to require specific evidence of need, such as evidence of the actual use of the vehicle for business purposes before the accident and the use to which the hired vehicle was put during the period of hire. So if we're dealing with a claimant who is a company who has a fleet of vehicles, then the claimant would be well advised to get some documentary evidence about what the vehicles are being used for, and perhaps at the very least have oral evidence provided by the individual who is in charge of the fleet, not just somebody in the company who has no connection whatsoever with the fleet of vehicles. So the court is entitled to have that sort of kind of evidence when it's assessing need from a company. I'd also advise that if you are in that situation and you're facing a large hire claim as well, you might want to also look at the case of Park Lane and Whip, which is a 2009 unreported case from His Honour Judge Harris, who is a judge who has dealt a lot with credit hire himself, and who's something of a, although obviously it's not binding authority, it is a further authority about companies' need. Moving on from that, there's then a question which arises on need as to whether the claimant can establish a need for a like-for-like vehicle. So, for example, if the claimant is driving a luxury vehicle, let's say a Mercedes, is it right that the claimant should be entitled to hire essentially the same kind of vehicle, so a luxury or prestige vehicle for the hire period? Or would their duty to keep their losses to a minimum, and their duty to mitigate, indicate that they in fact could hire a less prestigious vehicle for the period of the hire if, for example, all they needed was to travel around and maybe get their family from place to place? I think it's fair to say that there's no settled judgment about this at appellate level. There have been a number of cases which have discussed whether the need for a luxury vehicle has been made out. These are three which I've cited. Generally speaking, I think in cases of luxury vehicles, the defendants should, when they collate evidence about what the appropriate rate should be, and I'm going to come on to that in a moment, the defendants, when they're collating that evidence, would probably be well advised, and sometimes you do see this, to include an alternative non-luxury rate in the event that the judge might find that the need for a luxury vehicle like a Mercedes or a Porsche isn't made out, and there will be a significant saving that a defendant can make by providing that evidence, and if the argument succeeds. Now, whether the argument essentially is simply that the claimant has a need because they like the vehicle that they've chosen to drive around, and that they should be entitled because of that, or whether, for example, they have to present an image to their clients as being someone who's successful. It'll vary from case to case, but I'd say that it's still possible to argue both sides of that. Moving on then to this central issue of impecuniosity. This is, I think, an important, maybe even the most important point, because this is essentially what allows a party to recover, if they prove that they're impecunious, the entire credit hire rate. So this is the sort of the exception to the rule that we saw stated in Diamond and Lovell on the earlier case law, that what is only recoverable is essentially the spot rate, or the credit hire rate with everything, all the additional benefits stripped out. First thing I say here is, of course, remember to properly plead it. You've got to not only include the assertion that you're relying upon it, but any facts upon which you rely surrounding it. I was in a case, for example, where the claimant had asserted in their witness statement that they were impecunious because although they had savings in a bank account, those were for a wedding that they were having in a few months. Seems to me a perfectly fair assertion to make, but they hadn't pleaded it. And in those circumstances, I think that is precisely the kind of fact that you would expect to see in a pleading, because that would put the defendant on notice that perhaps some evidence was required of what these future costs were going to be. But setting that to aside for the moment, the most important case on impecuniosity, which set down the general principle, is the case of Langdon and O'Connor. This was a case where a number of members of the House of Lords gave opinions about what impecuniosity was. And the county court, in my experience, seems to have alighted mostly upon the tests as set out by Lord Nichols, where he says that in the present context, what it signifies is inability to pay car hire charges without making sacrifices the plaintiff could not reasonably be expected to make. Now, I think the reason why county courts have gone with that is because it incorporates the reasonableness element, which is, of course, the whole law of mitigation, basically. The law of mitigation is the claimant has got to act reasonably to mitigate their loss. And so this incorporates, I think, that general test of reasonableness. However, Lord Hope gave a slightly different test, which suggests that the criterion that must be applied is whether he had a choice, whether it would have been open to him to go into the market and hire a car at the ordinary rates from an ordinary car hire company. I think perhaps if you are a claimant, you might want to emphasize that test as being maybe a slightly less stringent one than the one given by Lord Nichols. But certainly, in my experience, if you're arguing the case about impecuniosity in front of a district judge in the county court, and you were to assert to them the question is one of choice, that you might get a raised eyebrow. Most judges tend to go with the reasonable sacrifices test. So it's not a precise concept, but it's an important concept because it's what essentially allows the claimant to recover the full credit hire rate, as I've said. And of course, the way most county courts deal with this is that they will have standard form directions when essentially the orders are typed up to either go onto the fast track, the multi-track, or the small claims track. And those standard form directions, when they give orders for disclosure, witness statements, general directions, will usually ask for the claimant, if they are asserting impecuniosity, to provide bank statements. And the usual order is for 3 months prior to the hire period starting, and then throughout the currency of the hire period, plus any pay slips, and plus any kind of credit card accounts or other accounts in which they might have any money. Basically, a full financial disclosure from the period 3 months prior to the hire period. Now, in my experience, it's actually surprisingly easy for claimants to not provide all that information. It's very, very frequently I find that you get to court and someone tells you that they have a Monzo account that has no money in it, but it still exists, or that they have a further credit card, which again they seldom ever use, but which does happen to exist. And usually the sanction within the order which is provided by the county court will be that if all the relevant disclosure hasn't been provided, the claimant is debarred from relying upon impecuniosity. They can no longer assert it. And again, speaking from personal experiences, district judges tend to apply those debarring orders very strictly. Perhaps if it's in the small claims track, part of the attraction of applying the debarring order strictly is that it keeps the running time of the hearing down. They don't have to deal with the impecuniosity point. That may or may not be the case, but certainly they are strict orders, and they can have important implications for how much you can recover. So my advice to claimants would be make sure you have all the documents, not just the ones that you think are relevant. Even if you have an account with nothing in it, you can guarantee the court will want to hear about that. And you'd be very well advised as a claimant to be able to give quite a full account of your finances. If you are in a position in cross-examination where you are asked questions about certain sources of income that are coming into your account, you can't give a really accurate explanation for them. It may well be the district judge will simply say, well, I'm not satisfied that the claimant has provided sufficient evidence to convince me of his financial situation, and I'm not going to be satisfied that they're impecunious. So that's, of course, the one point. The second point is that there have been a number of cases where defendants have sought pre-action disclosure of financial records to essentially verify an assertion of impecuniosity. Certainly, I can only see this being proportionate in quite large credit hire claims, but it's understandable why defendants would want to see that as early as possible, because it really does affect the defendant's ability to assess offers if they don't have a clear idea of whether impecuniosity is likely to be proven or not. Usually, once the full disclosure has been provided, it becomes quite, one can quite easily work out what side of the line that they fall on. If you have a claimant who's continually in arrears in a bank account, who is continually, in the red on the credit card, that's quite simple. But it's important that full disclosure is provided. So once the judge has been able to assess whether the claimant had sufficient funds to go out onto the market and rent a car at the spot rate or the general market rate on the high street, the next thing to consider is period. And the reason why impecuniosity, I've considered it before period, is because we now know that it's relevant to period and to the rate. So the general principles that apply to period, pardon me, are the same principles in many cases that apply to need. If you can establish that for a period of the overall length of the hire, that the claimant didn't in fact have a need for a vehicle, for example, if they were in hospital or they were on holiday, obviously that period should fall to be reduced or stripped out altogether. Other mitigation issues do, however, also arise when discussing the period. Now, the most frequent issue which is come across in pretty much every small claim, every fast track, every multi-track, is a delay on the part of the repairing garage. Usually the engineer's report initially assessing the vehicle will give an indication of just how long they think the repairs will take. And that will usually be quite a conservative estimate, I dare say. In some cases, only 3 to 4 days. But unfortunately, we know that garages up and down the country can sometimes be lackadaisical or simply very busy. There is no joy for the defendant on this point in nearly all the cases that I've considered. Generally speaking, delays on the part of the garage are unlikely to be the claimant's responsibility. The claimant, of course, has acted reasonably in most cases in sending the car to a garage. In many cases, the claimant's solicitors will chase the garage for information about the period, but really, once the garage has got it, it's pretty much in their hands. Now, there are options available to a defendant if they feel that the garage has essentially delayed unduly, and one of those is to make a claim for a contribution under Section 1 of the Civil Liability Contribution Act 1978. But I've never seen that done, and in most cases it would be disproportionate. It's also difficult where the repairs have been arranged by the claimant's own insurer to hold the claimant personally liable for any delay which has been incurred. Again, a contribution would have to be sought against the insurer, and that's very rare. As to period, as you'll have seen here, the case of Zurich and Emergi has established that impecuniosity is going to be relevant to the period as well as to the rate. If a claimant could have repaired or replaced their vehicle from their own funds in order to shorten the hire period and thus mitigate their loss, then what the case suggests is that they can't simply sit on their hands and wait. What happened in that case was Mr. Emergi was involved in a collision which resulted in him hiring a vehicle for 591 days at a cost of almost £100,000. And I think the Court of Appeal found in that case that the claimant should only be entitled to recover the hire charges up to the date when he should reasonably have purchased a replacement vehicle. And the court felt that it was reasonable for Mr. Emergi to have waited until an assessment had been made of his own vehicle as to whether it was economical to repair or not. And then until the defendants had an opportunity to inspect the vehicle and indicate whether it was agreed that it was a total loss or not. And then it was essentially reasonable to wait to that point, when it was affirmed it would be a total loss, to then go out and start looking for a replacement vehicle, which might take 2 weeks or so. So the take home from that case for defendants really is that if there's been an accident and your driver is at fault, you need to respond quickly with an indication as to whether you wish to inspect the other party's vehicle, particularly if it's a total loss scenario. If it's a total loss scenario, it may well be that if it's an expensive vehicle, that you would wish to inspect it. If, however, it's and this is often the case in total loss scenarios, that it is essentially an old vehicle which has been written off because it would be uneconomical to repair, it would be well advised for defendants to indicate quickly that they don't wish to inspect. Because in this particular case, what happened was that the defendants didn't do that, and a substantial period was still awarded, 140 days. So, of course, it's good authority that a claimant can't be running up higher charges indefinitely when they've not proved they're impecunious, because they should at some point have the vehicle repaired or replaced if it's a total loss. But it's still reasonable for them to wait until a defendant indicates that they don't wish to inspect them, to then go on and get a replacement vehicle in order to take themselves out of hire. So important case for both claimants and defendants, potentially large ramifications if you're a defendant who doesn't respond to a request for you to clarify whether you want to inspect or not. So then, having determined what the period of the hire should be, the court can then look to the rate. Now, if the court has determined that the claimant is impecunious, that is, that they couldn't have afforded to go to an average high street provider like Avis or Hertz or Europcar, they couldn't have afforded to do that, then the analysis will stop here, because in that particular case, that is the loophole to the exception. That is the loophole or the exception. They can then, of course, achieve the entire higher rate. But if they haven't achieved or convinced the judge that they are impecunious, then of course, the assurance that defendants can have is that all that they can recover in that case is the basic higher rate for the period which the court's determined was reasonable. Now, the way defendants usually go about obtaining this evidence is that they get a form or a survey of what the local providers of the hire vehicles have got from a legal services company, usually. And this is usually referred to as basic hire rates evidence. I think the case of Bent, the case of Darren Bent, the famous footballer, has established a few things about what the basic hire rates evidence has to be, or what it doesn't have to be, more precisely. There's no need for it to be exactly contemporaneous. I think in that case, there was rates evidence which had only been provided a year after the event, but that was still provided to be adequate. And there is no need for the rates evidence to be for the exact same vehicle that was hired. There is, of course, a number of vehicles that might be able to essentially provide a basic hire rate in this case. It's then, I think, followed by, I think, the most important case about rates, which is the case of Stevens and equity. This lays out the test in quite succinct terms at paragraph 36. It says it follows that a judge faced with a range of hire rates should try to identify the rate or rates for the hire in the claimant's geographical area of the type of car actually hired by the claimant on credit hire terms. If that exercise yields a single rate, then that rate is likely to be a reasonable approximation of the basic hire rate. If, on the other hand, it yields a range of rates, then a reasonable estimate of the BHR may be obtained by identifying the lowest reasonable rate quoted by a mainstream supplier, or if there is no mainstream supplier, by a local reputable supplier. So that's a fairly clear statement of the principle. As far as I can see, the courts have still found, despite the use of the word of the type of car actually hired by the claimant, it's still the case that basic hire rates evidence can provide a number of different vehicles in the same broad category as the claimant's vehicle. I don't think that's I think what the judgment in Stevens was getting at. Now, of course, the Stevens judgment also lays out, I think, quite helpfully for defendants at paragraph 34, that this is a rough exercise and that the court shouldn't be held to a counsel of perfection when calculating what the basic hire rate of the period ought to be. And that's quite helpful, because sometimes you get claimants arguing or making arguments that there should be a very precise, this should be a very precise exercise, that essentially if it can't exactly approximate the kind of thing the claimant would have done, or where we simply, there are too many imponderables, that the court should simply throw its hands up and say they should allow the credit hire rate. But that's not what Stevens says. That Stevens accepts, I think quite properly, that this is only a reasonable approximation is what can be reasonably hoped for. So to summarize Stevens, what we're looking for is the lowest rate for the type of car hired or its equivalent. It needs to be in the geographical area, although in the age of the internet, and I think the geographical area can reasonably be extended. I don't think there's any hard and fast rule about, in terms of miles, about how far that would be, but it's certainly, I'd say a good distance. And the supplier has to be a mainstream or local reputable supplier. So it shouldn't be from, it should be from a generally speaking, from a supplier which you've heard of, or from a company which is essentially well known in the local area. It can't be from Joe Bloggs down the street, who I think has a spare Fiat Punto on his hands. So this case, essentially, defendants, I think, benefited from that. And I think the from that acceptance in Stevens, I think that this was an approximate exercise. And I think defendants also benefited in Stevens from the fact that the Court of Appeal affirmed that the relevant rate was the lowest rate that could be established by a survey of the local companies. I don't think claimants, I think, tried to get around that. And I think in McBride, they tried to essentially push back against Stevens somewhat. But it didn't have that effect. The case of McBride in 2017 affirmed the rule in Stevens that it is the lowest reasonable rate. And I think that also was of some assistance to defendants. The other point that was considered in McBride was that how should the court approach a situation where none of the basic higher rate providers offer a nil excess product. So when one goes out onto the market to find a car from a regular provider such as Avis or Europcar or Hertz, of course one pays the rate of the basic of the hiring the vehicle, and that's a flat rate. But then on top of that, what must also be paid is a product which essentially pays an excess product, basically an insurance product. And it's been held, I think, in McBride, that the court should not allow the credit hire companies offering a nil excess on prestige vehicles with other car companies. Sorry, I can't read that because of where my screen is. Should not allow the credit hire companies that offering a nil excess on prestige vehicles. They shouldn't be allowed to use that as a smoke screen to enable credit hire companies to recover the charges in full. So what this is saying is that some companies like Europcar or Avis will not have an excess product for their prestige vehicles that reduces the excess to zero. And that is a commercial reality. But the credit hire companies shouldn't be allowed to use that to say, well, because such a product isn't being provided, the court must award the full credit hire rate. What McBride essentially said is that the excess product and the product and the separate rate which is being paid for the hire of the vehicle are two segregable separate products, and that where you can't get a product from the spot hire company that provides a nil excess, then you can essentially cut that off for the main hire period and analyze that in a separate way. So it says here that where a nil excess is not available, the correct approach is to treat the nil excess separately from the comparison exercise between the default credit hire rate and the basic hire rate with an excess. It will almost inevitably be the case that it was reasonable for the claimant to seek a nil excess for the reasons given in B in Jensen. And on that hypothesis, the only question for the court will be how much should be recoverable as the cost of purchasing a nil excess. So what happened in McBride is the court awarded the basic hire rate provided on the general spot market, plus the credit hire company's collision damage waiver rate. And so the two were found to be segregable. But the court went further and looked at some certain products which can be obtained by a claimant, which essentially aren't collision damage waiver products. They're not insurance products. They're insurance reimbursement products. So that they're products that will essentially pay your excess if you have damaged the vehicle. And these products are very helpful to defendants because they're very cheap. And the court in McBride said that in paragraph 77, because of the sheer number of these products and their availability on the internet, it should be considered by the court that they can be incorporated into the court's reasoning. And I think in Clayton, which was the appeal that was heard alongside McBride, the court went further and said that these products should be regularly admissible. It said the court should admit and accept such evidence as evidence of the reasonable cost of obtaining a nil excess, provided, of course, that the quote obtained from such provider is for a car which is comparable with the one hired from the credit hire company and is for the same period as the period of actual hire from the credit hire company. But my understanding of McBride is that where there is a vehicle available on the spot market, on the high street, that does have a nil excess, then the court should use that product first. If there are no cars upon which it's possible to obtain a nil excess, then in that particular instance, the court can then resort to either utilising the collision damage waiver charged by the credit hire company, or in all other circumstances, the very cheap sort of Questor or insurance for car hire products, which reimburse the insurance. But that's only where none of the products available on the market after a survey of all the reasonable rates can provide a zero or nil excess. Then when looking at rates, in my experience, certainly in small claims and fast track trials in the county court, there's usually a degree of debate as to whether a weekly rate or a daily rate should be used. Most car hire products, or car hire providers, should I say, they provide a number of different rates as part of a package. And usually the weekly rate will provide a hugely discounted price from the daily rate. Usually you start to make a saving on the weekly rate if you hire for more than 2 days at the daily rate. And then there'll be a monthly rate as well, which rarely comes into play because usually a month is far too long a period to apply in a credit hire context. I think a case to refer you to in this instance would be Bunting and Zurich Insurance. Of course, it reaffirms that what claimants can't do is nitpick a judge's analysis of what the reasonable basic hire rate ought to be, sorry. And whether a weekly or daily rate is employed will really depend on a number of factors, but the most important one will be the estimated length of the repairs. As I've said, usually if a claimant is hiring for 2 days or more, they'll make a saving on the weekly rate. The more contentious issue here is whether you can subdivide a weekly rate or salami slice it, as I sometimes say. Some courts are more amenable to this than others. The court in Bunting and Zurich Insurance permitted there to be a subdivision of the weekly rate. But I would point out that if you're for a claimant, the court in that case had actually heard oral evidence from the provider of a basic hire rates report. And in that case as well, the period was quite long. I understand it to be more than 40 days, I think 42 days or so. And so the evidence of the person who compiled the basic hire rates report was that the company providing the hire vehicle would have allowed for a subdivided rate. But the court doesn't lay down a hard principle in that case. And certainly, if you're a claimant, it's worth making the obvious point that if the company's hiring vehicles allowed for the weekly rate to be subdivided, that would defeat the whole commercial purpose of providing a discounted weekly rate. And that is simply not a rate that's available to the public And I think a lot of courts are still accepting that argument. In terms of, we're nearly at the end now, so stay with me. In terms of any extras which might be secured on the general sum that might be awarded for a basic hire rate, it's important to remember that the basic hire rate needs to be applicable to the particular claimant. It can't just be any kind of rate. So, for example, if the claimant is a young claimant, if they're usually under a certain age, many high street providers include a high risk driver charge, or in some circumstances they don't even allow for that person to hire at all, and that can be an important consideration. So ensure that if the claimant is younger or older, then there's been adequate investigation of whether the rates included in the basic hire rate survey will provide for that. Also, there'll usually be a sum for collection and delivery. That seems reasonable to me, where the claimant has got a damaged vehicle and they can't get to the hire company's premises. Usually the credit hire company will provide the same sort of service. But if the hire company doesn't provide a collection or delivery service, usually what happens is the person that compiles the basic hire rates evidence will have included a taxi fare for travel to and from the hire company's premises. And so that can be added on as a reasonable extra. So once the court has done all that, the court will make a calculation for what the reasonable basic hire rate should be. So if you are a claimant and you've established that the contract you entered into with the hire company was an enforceable one, and you've established that you were legal, well, essentially that there's no bar in terms of illegality to your claim, and once you've established your need for the vehicle for a certain period, but if you haven't established that you were impecunious, then the court will essentially apply the basic hire rate established in a witness statement provided by the defendant to the relevant period, and will make the calculation accordingly. So it's a rough and ready calculation, but essentially it's important to remember to bring a calculator to court if you are if you're a defendant, because it will involve some number crunching in the end. And that's it. I think it's important to say at this juncture some important points that I haven't covered. Obviously, I've not done absolutely everything, because that would have been impossible. And this is a substantial area of law, and there's a substantial body of case law. Many of the cases I've not referred to. I've just referred to the ones which I think have been the most important. What I've not gone into, and which is an important, and I think it should be treated as essentially as a separate issue, is where the vehicle is a profit-earning chattel, such as a taxi. Now, that is dealt with in a case called Hussein and EUI Limited. Be very careful there. That's a different kettle of fish, and there are very significant ramifications if it's a profit-earning chattel for how you plead the case. So I'd recommend strongly reading that carefully. I've also not covered intervention letters. Sometimes the defendant sends a letter to a claimant following an accident, saying that they're prepared to essentially pay for their hire car. There are certain requirements that such a letter has got to meet, and certain other legal requirements that have got to be met by the defendant. And that's covered in a case called Copley and Lawn, and I've set that out there. Intervention letters are not infrequent, but most cases that appear in court tend to simply focus upon the principles I've set out here. So enforceability, need, period, rate. And I think that after, if you're still with me after all this time, that concludes my presentation. So I hope that I don't expect you'll be regaling anybody at dinner about all the exciting credit hire talks and cases that you've been running, but it does represent a significant proportion of litigation in the county court, and so it is an important area to be au fait with. I hope that you'll continue to join us for any further introductory practitioner talks that we might have. And I think this will be the first, or certainly one of the first in a much larger series, which is exciting. But in any event, all that remains for me to do is to thank you for your attention, and hope we see you again shortly in one of these talks. Thank you very much.